Good afternoon. I want to welcome you to the Lunch and Learn presentation, League of Women Voters of the Monterey Peninsula. I'm Beverly Bean, president for this year. And thank you all for coming, and I want to particularly thank Vicki for the excellent lunch that she arranged. I'm going to turn it over to George now so that he can introduce our speaker on the initiative and referendum process.
Thank you. I feel pretty lucky that we were able to get Michael Salerno to address us today. But it only reminds me of a joke. Basically, there are two attorneys that went into a bar, and one of them was Michael Salerno. That's as far as I've gotten on the joke. I was trying to... Michael's been around. He doesn't look like he's been around as long as he has, but based on what he's been able to do in a fairly short career, it seems to me that he's the right person at the right time for us and for the league, the state league. He's been his experience. He went to UC Santa Barbara, undergraduate. He got his law degree from Davis. He's been a Fulbright scholar. He's been visiting professor at San Diego. He's been into the Mexican, I'm not sure how to say this, but their law institute. He's been a visiting professor there. He was a short spell just a few years ago as director of the Fair Political Practices Commission. And that is a whole different dynamic, a whole different area of responsibility. But he's been a student and a practitioner in the issue of democracy for a long time, and he's it's kind of a public interest and financial interest and democracy interest baseline. So if it serves democracy, he's in the middle of it. If it threatens democracy, he seems to be in the middle of it. If it kind of could expand and improve on democracy, he's in the middle of it. And so that's why I feel like we're particularly lucky about it. He's been writing and active in this area for a long time. The legislative process, the budget process, bill drafting, just political law in general, which includes ethics, always interesting, political reform, financial interest, conflict of interest, campaign finance. I mean, you name it, he's been there. And he sees some cracks in the system. He's here to tell us a little bit about that point of view, his point of view on the initiative and referendum issues today. And without any more introduction, I'm going to give you Mike. I think he's mic'd up as well.
Well, thank you very much. You're far too kind. And thanks to the Monterey Peninsula League of Women Voters for the invitation. I'm delighted to be here. I should say make a couple of preliminary comments. First of all, I'm in a second career teaching at UC Hastings, which is my occupation now. Prior to that, I was an attorney for the legislature, and I did various and sundry things. The views I express today are my own. They do not reflect any perspective from UC Hastings College of the Law. And the views I have are based on my personal experience. I've not been affiliated with a political party for decades. When I worked for the legislature, prior to going to, well, I've worked for both Democrats and Republicans. I have no party affiliation. I object to both parties. But I spent the lion's share of my career to date in the Office of the Legislative Counsel, which is the impartial, nonpartisan entity that provides legal services to the legislature. And so I've scrupulously protected my impartiality and my nonpartisanship. So I've been on a variety of these panels over the last few years, but for my experience with the Alameda League of Women Voters, it's been a negative experience for me because I'm always put on a panel, and I turn into the piñata of the panel. I put on the panels with another attorney who drafts measures, a political consultant, a PR expert that does focus groups, somebody from the media that sells advertising spots for initiative measures. So generally speaking, everybody at the table has an economic and financial interest in what has become a cottage industry in California, the direct democracy initiative industry. And I guess that's what I object to. And I'm going to start the way I started in Alameda. Have you folks had enough yet? I mean, this last election, and these are preliminary figures. I ran into the chair of the FPPC, who I think quite highly of, Ann Ravel, and she was telling me the final figures are coming in. She was going to try to get them to me for this speech. They weren't finished being tabulated. But when I took a look at this in December, it was almost $350 million spent on initiative campaigns, pro and con, in the November election. That number is just going to go up. And of that, we have $11 million that we don't know where it came from. And that's one of the things I admire Ann the most of. She's just being very dogged in trying to figure this out, where they've traced it to different states and the money's been funneled around. 4 months after the election, we still don't know where the money came from. So have you had enough? Have you had enough of the mongers? I don't know them personally, but I'm offended when any one person can put something on the ballot and bankroll the entire campaign, and that goes for the same guy who owns Mercury Insurance. And I mean, the list is endless. I mean, this is not what I think of when I think of democracy. The ability to circumvent, the popularly elected officials and just go directly to the ballot, generally with a very, very misleading campaign that has nothing to do with the particular measure, because it is the product of focus groups meeting to figure out what buzzwords appeal most to the voters and what pitch to give them. I mean, I wish I brought my audio-visual aids. I would run a couple of Prop 32 commercials. I mean, how can you be more misleading than that particular campaign? And those people who defend our current process go, oh, geez, well, this just proves it works. The system works. The measure was defeated. $350 million later, why are we burning all of this money and doing this in the way that we currently do it? And it's a broken system. California is one of the most extreme examples of the initiative system. I've been to Switzerland, where the initiative was born. The Swiss system bears no relationship to the California system. And I'll talk a bit about that. But it's time to face reality. We're dealing with a big financial interest. Initiatives are big business. There's a lot of money at stake. And for the few million bucks, a couple million bucks you spent to qualify it, and the few million bucks you spend to get it passed will reap dividends in the tens of millions of dollars if you're successful. That's why these people do it. I mean, the whole notion, and I'm segueing into this, of this fairy tale that was told at the turn of the 20th century, which may or may not have been true then, that this is the voice of the people, it has to be confronted with reality. I'm going to talk about what I think is wrong and what I think can be done, and a lot of it can be done by, I think, within existing law. But there's plenty of blame to pass around for why the initiative doesn't work, or works in the manner that it does. And I think we start with the court, and then we move on to my pals at the legislature, and then we look at the voters themselves looking for that free lunch, and we talk about the media's involvement. Not the reporters, I'm talking about media as a business. They charge the highest ad rate during the election for initiative measure advertisements. The media has incredible, the business of the media has an incredible stake in the initiative system basically staying the way that it is. So let's start with the fairy tale. The fairy tale, and let me just quote from a recent decision of our California Supreme Court. The legislative power under our state constitution is vested with the legislature. The people reserve to themselves the power of the initiative and referendum. Accordingly, the initiative power must be liberally construed to promote the democratic process. Indeed, it is our solemn duty to jealously guard the precious initiative power and to resolve any reasonable doubts in favor of its exercise. Had this opinion not been written in the late 20th century, maybe in the early 20th century, maybe in the 1915, 1920, I'd say that's right. But as reforms are attempted and as the people who the reforms were aimed at figure out how to get around them, the same thing has happened with the initiative. It isn't the voice of the people. It shouldn't be liberally construed. It is put on the ballot a lot of times with wishy-washy language, with an intention in mind of accomplishing a goal that isn't clear with the voters that are voting on it. And that's the sort of thing that you got to strictly construe. You got to hold it down to like what it actually says. So I think that the court is off relative to its continued liberal interpretation. I think they're off observing this notion that it's not the voice of special interest trying to circumvent our democratically elected legislature. It's not the voice of the people. In rare instances it is, and we can celebrate those instances, but they're rare instances. It, generally speaking, is the voice of one particular interest over another that can't get their way with the legislature. So I would say my criticism of the court is abandon the fairy tale. Secondly, we have something in the California Constitution called the single subject requirement that says that a statute enacted by the legislature or an initiative proposed by the people has to relate to one subject. The California Supreme Court has rendered that meaningless. I mean, you can have the broadest subject in the world, and there have been a couple of cases about excessive generality, but speaking generally with their liberal construction, they tie them all together. My favorite example of a violation of the single subject is Prop 13, challenged in the Amador Valley decision. Well, Prop 13 did a bunch of things, all of them relating to property taxation and the ability to raise money on a local level. It had this one provision that was across the board. It now takes the legislature a 2/3 vote to impose, to raise taxes. There was a prohibition on raising property taxes in it. The restriction on raising taxes, general taxes, had nothing to do with property tax. The Supreme Court says in the opinion, we find that the subject is property taxation. Yet they just, with a throwaway paragraph, dispense with this additional requirement, which turns out to be one of the most significant things in Prop 13. You know, and the reason for the single subject is to focus it. Most people don't know the true reason for Prop 13 and who was behind it and who are the winners under Prop 13. Anybody want to hazard a guess? Commercial real estate. Howard Jarvis, president of the Apartment Owners Association. Well, they did this little symbolic crusade of Ma and Pa getting tossed out of their little shanty because they can't afford the real estate taxes anymore. Of course, they don't pan back to show it's in the middle of Beverly Hills, and they're going to get several millions of dollars when they sell it. But that was the really emotional argument where, you know, nobody mentioned business property, nobody mentioned commercial real estate that doesn't change hands. So it's reasons like this that you should have a single subject, and we get back to a strict construction of these terms, not a loose construction, because it's not the voice of the people, it's the voice of particular interests that are trying to circumvent the legislative process. Now, I should say also as a preliminary matter, there are some people who feel the initiative process is violative of the U.S. Constitution. And Erwin Chemerinsky, the dean of the Irvine School of Law, UC Irvine, is one of those people. And if you're curious about it, I'm going to give you a great article he wrote called Challenging Direct Democracy, 2007 Michigan State Law Review at page 293. He thinks that they're unconstitutional because of the guarantee clause in the U.S. Constitution that guarantees the states a Republican form of government, which is generally thought of to mean a representative form of government, and this is contrary to them. The one time the U.S. Supreme Court looked at the issue was around the turn of the 20th century, and they said it was a political issue that they weren't going to determine whether or not there was a violation. I mean, I think that they punted, but that's the state of the law. I'm not opposed to initiatives, referendums, to direct democracy. I just think that the way that they're done has been a recipe for disaster. In my view, again, this is my view, I think the initiative process has ruined education in California. Just decimated it. We start out with Prop 13, taking away the abilities for locals to raise money for local schools, making funding of local schools a statewide matter, followed up by Prop 98, which is not equally bad, but it is pretty bad too. It came up with a formula. And then we got into the crime business with Victims' Bill of Rights. Again, if you look at the measures, they're violative of the. I can't imagine how anybody could read them and think that they're not violative of the single subject. They are so expansive. 3 strikes, you're out. So we're out. We have replaced the finest public university in the world with one of the largest prison systems. We spend more money imprisoning people than we spend on higher education. And how did this all come about? It wasn't a rational decision. It was a series of ballot measures that present binary choices, yes or no, very, very skewed discussion of issues, and attempt to persuade the voters to go down a path that is very difficult to correct. So I think that the court can rein this in if they wanted to. I think that if they got serious about defining single subject as strictly, and the same thing relative to the differentiation between is it an amendment or is it a revision, I think that they have to come up with a much better distinction. They've only found a revision in the past few years once, and when it affected the Supreme Court's power. Otherwise, I thought that Prop 140, the initial term limits, was a revision of the Constitution. It dramatically changed the power dynamics between the branches of government. The Supreme Court didn't see it that way. There was discussion in the legislature at that time of putting on the ballot a constitutional amendment during the pendency of the Prop 140 case that would have cut judicial, appellate, and Supreme Court terms in half, limited them to 2 terms, eliminated their retirement, cut the amount of money that could be appropriated to the courts, and have that running at the same time. Now, would the California Supreme Court look like at a measure like that and say it's just an amendment, it's not a revision? I don't think so. I don't think so. So abandon the fairy tale, strictly construe single subjects, and differentiate in a meaningful way between amendments and revisions, and really have amendments being more minor changes rather than these dramatic changes. So let's move on to the legislature, because I want to be an equal opportunity abuser, and I have a greater affiliation with the legislature. First of all, they really should take their responsibility seriously, and they don't. They punt. There is a provision of the Government Code, Section 9007. Immediately upon the preparation of the circulating title and summary of the proposed initiative or referendum measure, the Attorney General shall forthwith transmit copies of the text of the measure in circulating title and summary to the Senate and the Assembly. The appropriate committees of each house may hold public hearings. Now, you talk to the folks at the legislature and they go, oh, there's so many that get qualified for title and summary, they're all circulating. This is impractical. Well, yeah, literally that's true. But I can tell you on day one whether something's going to be on the ballot. Just look at who's behind it. So if you've got 25 out there and you figure 5 of them are going to make it, try concentrating on the 5 really quick and start drawing the public's attention to what they're trying to do. So it's not this rush to judgment as it is in California. In Switzerland, the birthplace of the initiative process, it's a year-long process. It's a collaborative process with their parliament. What ultimately at the end of the year winds up on the ballot can be the original, unadulterated proposal by the proponents, but it can also have an alternative proposal. It can have a compromise proposal. They're all voted on. If they all pass, then it's up to the parliament to try to put them together and harmonize them. And at these elections, they send very, very detailed descriptions of each of the measures to every voter, and they don't vote on candidates. They have an election a year just on initiative measures. So the focus isn't, the presidential or the gubernatorial campaign. It's on the business at hand. It's on the initiative. So totally different, totally different. So the legislature, if they wanted to, and they do have hearings, but they're perfunctory hearings. They just do them just to get them out of the way. The legislature could draw tremendous attention. Short time frames that are set forth in the California Constitution, the 131-day provision, has to be expanded. I mean, these are important decisions. We need to take more time at them. Another thing that the legislature can do, and I'm really out on my own on this one, but I think I'm right, is I think that the legislature currently has the power to place competing measures on the ballot by resolution. Okay? The California Constitution specifies a procedure to put a constitutional amendment or revision on the ballot requiring a 2/3 vote, but it is silent as to putting measures on the ballot that are only effective if they're adopted by the people. So why do I say that? And I'm going to quote from another case. A legislative assembly, when established, becomes vested with all the powers and privileges which are necessary and incidental to a free and unobstructed exercise of its appropriate function. The Constitution is not a grant, but a restriction upon the power of the legislature. And that's how state constitutions are different than federal constitutions. The federal Constitution is a grant of power. If the federal Constitution doesn't tell Congress it can do it, Congress can't. They have limited powers. The state constitution, conversely, is a limit on the power of the legislature. If the state constitution doesn't prohibit it, and it's otherwise not unconstitutional under the federal constitution, the legislature has the power to do it. So when it says the Constitution is not a grant but a restriction of the power of the legislature, and hence an expressed enumeration of legislative powers and privileges in the Constitution cannot be considered as the exclusion of others not named unless accompanied by negative terms. Okay? New opinion. Ex parte Deal McCarthy, 1866. Repeated in the People's Advocate case in the 1980s. So there is a question whether or not the legislature, and I've had conversations with various members of the legislature, and my good friend, the pro tem, is talking about putting a measure on the ballot to explicitly give them the power, and I'm arguing against that because that gives the courts the notion that they don't have the power because they're asking for permission. I think that they should just go ahead and do it. Do it relative to one initiative. If the court doesn't like it, the court will certainly tell them. I don't know what their legal basis for telling them to do it. But relative to the legislature, use the statutory authority that they have now and push the envelope and try putting a competing measure on the ballot. What do the people lose? As long as they don't touch the original measure that's the people's proposal, it just is another alternative. More choices are better. I talked briefly about the voters, and it's free lunchtime. Okay? You put stuff on the ballot, and if it offers something for free, and that's the problem with ballot box budgeting. That's not how it works. There are many moving parts. It's not just a yes or no decision because it affects so many other things. And if I were king, in terms of changing the process, I would not permit fiscal matters to be on the to be resolved by the initiative process because they just toss the fiscal very delicate balance totally out of kilter and strange things result. As Prop 98 demonstrates, that was thought of to be a floor in terms of funding K through 14 education, and it's turned into a ceiling. So we could make a pretty powerful argument that Prop 19 has held down the amount of money that is appropriated to schools. Ultimately, in terms of fixing the system, I think that if we did some fundamental things, and your position paper covers some of them, we could go a long ways in improving the process. Again, I'm not against direct democracy. I'm very much in favor of referenda. And referenda, as it is classically meant, is the ability of the voters to nullify an action of the legislature. Now, what it has come to mean in California since we have the initiative is it's the ability to nullify something that's been enacted by the legislature but is yet to become operative. That's why there's this real short time frame into filing for a referendum. So you've got to get the petition circulated and completed before January 1st when the measure goes into effect. Otherwise, if it's existing law, you need an initiative to change it. Under classic referendum, you can, subject to approval of the voters, something that's been just passed by the legislature or a law on the books. But it's a negative power. You can't positively offer something. It's got to be a repeal. Whether or not we have a referendum in the U.S. Constitution was something that was debated at the Constitutional Convention and rejected because there was a belief in republicanism, small r, where it's a representative democracy. We elect people that we theoretically have trust in to spend the time to make the decisions. So just getting back to whether or not the initiative is a good idea, that wasn't even discussed at the Constitutional Convention because it wasn't around, but even the referendum, which is a far more limited power, was rejected in favor of republicanism. So how would I change the system if I were able to? The most important thing, and I think that can be at least highlighted by the legislature if they wanted to, which is how the measure's drafted and who drafts it. I personally think it should be done by a neutral entity where it is a public process, where the language that is used is discussed, and where there are no hidden meanings for things, and we come up with language that says what we mean and mean what we say. And so when we pass something, we have certainty of what we've passed. And if we make the drafting process a collaborative public process where before the petitions are even circulated, we have a clear, we get the proponents in a public forum to explain what this clause means, what their intention is. We establish a record before it's passed and then goes to litigation and people get into their litigating postures and what they're really trying to get the law to mean. So drafted in public. I don't know if you folks know that there is another provision of the government code, section 10243, that requires the legislative council to draft initiative measures if the legislative council's presented with a petition signed by 25 voters, and in the view of the legislative council, it's a real proposal. I think the language is, in the judgment of the legislative council, there's a reasonable probability the measure will be submitted to the voters. Well, that would eliminate a lot of measures. When I was at legislative council, I spent a lot of time drafting these measures. I mean, very few people know about it. People know about it, they take advantage of the services of the office. And drafting is a collaborative process, even with the best of intentions. Trying to get something down on a piece of paper that's read by everyone and means the same thing to everyone is a real skill. So drafting these in public, we currently can have them drafted by the legislative council, but do you think that any special interest that has an economic stake in a particular election is going to want the legislative council to draft a measure for them? Nah. They're going to have their own attorneys. They're going to have their own attorneys because that's where the power is. So I would, number one, draft them in public. Number two, the timing. This is the biggest impediment because it's in the Constitution. Everything else is statutory. Legislature can change it. Legislature can't change the language that says, let's see, requiring the Secretary of State to submit the measure at the next, that's qualified at the next general election held at least 131 days after it's qualified. That's a pretty short time frame. And if we could, give the Secretary of State a greater ability to not put it on the next general election or the next special election, but to require a period of time for the measure after it's been drafted in public and vetted and people have taken positions on what language means, then a period of time to educate the public relative to what a yes vote means and what a no vote means. I think would make all the difference in the world in terms of there being no surprises. I think that these things during that expanded period of time have to be vetted. I think we have to ask a lot of questions about these and figure out, once they are qualified to be on the ballot, what the likely outcome is relative to what they're trying to do. I love the idea that they have in Switzerland of having elections just for ballot measures and not confusing them with candidates, and really focusing on the ballot measure rather than who's going to be the next governor. And fundamental to this is who is behind the initiative. The disclosure we have is just a joke. It is too easy to evade. Even when we finally find out who these people are, it's the shouting after the decision has been made. And disclosure shouldn't be that difficult. It should not be that difficult. We can prohibit campaign contributions from being accepted unless the true identity of the donor is known at the time of the contribution. And the idea I like the most, and I got it from Fox News. You got to love that. You know, you've all watched these commercials, right? Political commercials, Jack and Jill talking over coffee about how horrible things are going to be unless the A, B, or C happens. And then at the end of the commercial, what was that? Get that freeze frame. Who paid for that ad? You don't know. Hey, that's where Fox News comes in. Now you can't regulate the content of a political advertisement because that's compelled speech, and our Supreme Court says you can't do that. But they don't consider it compelled speech by identifying the donor if you do it in a fairly inobtrusive way. So how is Fox News figuring into this? Has anybody figured this out? The crawl. You know what the crawl is? The crawl is that little line at the bottom that tells you, what the stocks are and da-da-da. Doesn't affect the broadcast, but there's information at the bottom. You know what the good thing about the crawl is? It lasts the entire time of the advertisement. So I'd say let's have a crawl on every political issue ad that tells us the name of the organization and who contributes to them. And we're going to have 15 seconds, 30 seconds, a lot of information crawling across the bottom of the screen, not affecting the message, but providing information to the general public. So that's a summary of my criticisms of the initiative process and what I think just minor steps could be done to correct it. Some of them can be done just if the legislature had the will to do it. Some of them are going to take a constitutional amendment. But I think even if we did the stuff that the legislature has the ability to do without any changes, we'd be far ahead of the game. So I wanted to leave a lot of time for questions because I know this is an issue that is near and dear to you, and I'm happy to respond to George.
Have there been any recent efforts to change the process?
Well, I mean, the current pro tem's looking at, I think, I was reading in the B, and I haven't personally discussed this with him or his staff, but I understand they're going to put in a measure that's going to make some changes. And I think the reason it's not public yet, or it wasn't as of yesterday, is that they really haven't decided dispositively what they're going to do. Yeah.
One of my first personal experiences with initiative was when I moved into a community in the Bay Area with 2 young children, and the new community didn't have fluoride in the water. So I organized a group and went to the water district and asked them to put fluoride in. And they thought it was so controversial, they would not make it.
It's communist plot.
Yeah, right. So then I organized initiative procedure in order to get it on the ballot.
Yeah, now, see, local initiatives, I'm less critical of than statewide initiatives because there's a lot more information floating around on the local level than there is on the state level, and I really don't express a view on local ones.
But Prop 13, it seems to me it was the legislature were not listening to the voters in terms of the property tax rise, and,
right.
And if people were doing their jobs as we would like them to do, I think there would be less.
Well, let me tell you about Prop 13, which is the worst deal going, and I have a vested interest. I bought a house I still own in 1976. my property taxes on that house are maybe a tenth of my next door neighbor. It's kind of the identical house. And I mean, that's great for me, but I mean, what is the public interest in that? I mean, I'm very sympathetic to people who buy houses in California and the property values just soar and they have an incredible asset on their hands. And it's unfortunate when they can't afford that asset, but I don't think the solution is freezing all of commercial property rates and giving, long-standing residents a benefit that I don't think is that just.
If our elected officials had been doing this.
But what would they have done? What's the solution?
Well, they could have done something else rather than.
What?
I don't.
Well, I don't either. I mean, but it offered.
Like you said, this wasn't a one-issue solution.
No, but the solution that was focused on was the problem you're pointing out. You don't like your property taxes because they reflect a percentage of the value of your property. So we won't do that anymore. We'll say your property taxes are going to be what your property was what your property was worth the day you bought it. Now, again, I'm sorry, and I'm speaking against my interests, because my property taxes should be 10 times what they are. But it just doesn't make a lot of sense. And people voted for it to protect their own. They didn't vote it for the public good. They voted for it to protect their own interests. And I think that's unfortunate. So, sir.
I was wondering if paying signature gatherers to be prohibited.
Okay, they can't. There's a Supreme Court case on it.
It be required that they live in the jurisdiction
Can't.
for 60 days or 90 days?
Yeah, all restrictions on circulation, and they've tried it, and the courts have swatted them down. I mean, that's another thing, the paid circulators. I mean, they're paying $1.50, $2 a signature. As the voice of the people,
They don't even have to live in it.
They don't have to live. They don't have to live in the state. I mean, they have to, I think, express a present intention of staying and voting, right? Ma'am.
We had a speaker here about the Disclose Act.
Uh-huh.
Do you think the legislature will pass that?
Well, the Disclose Act is a federal. The State Disclose Act, the California's Disclose Act. I'm hoping. I mean, I'm going to be showing up and testifying in favor of it because I mean, how can anyone be against disclosure unless they're a proponent that's trying to hide something? I mean, this isn't rocket science, sir. Way in the back.
So, 2 questions. So there's
You only get one.
no restrictions a minor could circulate?
No, I think you've got to be old enough to vote.
Because the current code in Monterey County is that, I've seen it change, is that if you're qualified to vote.
You've got to be old enough to vote. I believe you have to be old enough to vote.
And then the second
Sure.
question is the Prop 13 the court case that took care of the single subject issue?
Well, no, the single subject is applicable to all initiative measures because it's part of Article 2, and it says a measure that violates a single subject may not be submitted to the voters, or if it is, have any effect. That's a ground rule. It's just that they've made it so elastic. The California Supreme Court has made it so elastic, it's as if it doesn't exist. And when I look at the sequence of cases, I think the first big time they did that was with Prop 13. I think they did it with Prop 8, Victims' Bill of Rights, even worse. And there are other members of the Supreme Court that share that view, but just not a majority. Ma'am.
Do you think that making it more difficult to qualify a proposition would in any way help, or would it just limit it to the rich?
I would not make it more difficult. I would not make it more difficult. I'm not interested in taking the rights away from the voters. I'm interested in the voters knowing what they're doing. So I wouldn't make it more difficult, because when you make it more difficult, that you're lining the pockets of the circulators. Because you got to remember, with these very, very powerful interests, spending a few $1 million to get something on the ballot and to promote its passage, and spending that money by employing these PR people who have focus groups and will give them information on how they can enhance the ability of this to appeal to the voters. And they say the most effective advertising is the one that you're totally unaware of. So making it more difficult plays into those hands, because even though it's millions of dollars to them, it's peanuts relative to the benefit they get. Ma'am.
I'm interested in the Swiss process
extraordinary.
Really?
Oh yeah.
Okay, what's the answer to that?
Well, I mean, it's a small, Switzerland, is a multi-ethnic country. The German, French, and Italian. But they're all Europeans. I mean, it's a fairly small country. It's nothing like the United States. It doesn't have the diversity. It doesn't have the size, and it's more manageable. And so, I think that a Swiss process could work in California, but it's far more complex because we're bigger, and the European obligation to vote is much more strongly felt than it is in the United States. In Italy, for example, if they have a referendum on the ballot, unless they get a certain percentage of the electorate voting for the referendum, it doesn't count, which is another interesting, thing. Now, what happens is if you're against the referendum and you see your side going down, you put out the word "don't vote" to try to get the vote down. So there are problems with that approach. But I mean, it's scandalous how few people vote in the United States. It truly is. I mean, as you look at, when it says you got a 65% turnout, and it's just fabulous. It's normally about high 40s, low 50s. That's not of all eligible voters. That's of people who have taken the time to register to vote. Because you have an incredible population out there that don't even register and aren't even counting relative to the percentage of people that vote. So it's a cultural thing, and I don't know how to make people feel that voting is really their obligation of being a citizen, which I think it is. Ken?
My take, I couldn't keep quiet.
Do you have a question?
Yeah.
Okay.
My take on disclosure, or the lack thereof, is that the lack of full disclosure makes the California election open to anybody in any state. Because I, as just to take a state, could be from Oklahoma and have a hell of a lot of money, laundered money all over the place.
I'm looking for the question, Ken.
Don't you agree?
Next question. Sir.
Of the various reforms, what would be the easiest one to start with?
The easiest one to start with would be for the legislature to assert some power and actually pass a statute, which they can do by a majority vote. They've got 2/3 majorities of the Democrats in both houses, that sets up a statutory procedure for a legislative resolution to appear on the ballot as a proposal, effective only if adopted by the people. In the next controversial proposition that comes along, put an alternative on the ballot and see how that works.
Could you say that again slowly?
Okay, I said, have the legislature pass some legislation that sets forth a statutory framework to get a resolution passed by the legislature on the ballot, just a process, not with respect to a specific one, just a process, acknowledging the legislature's ability to do it. And then the next controversial proposition that comes along, actually have hearings on it and come up with a legislative alternative to it and have it appear on the ballot and have the California Supreme Court tell the legislature they can't do it or they can. That's where I would start. Otherwise, I would, if there's not that much courage, I would say once a measure is submitted for title and summary to the AG, that's before it's circulated, that the elections and the elections committees of both houses take a look at its probability of being making it to the ballot, because there are a bunch of these that are done truly by citizens that have absolutely no chance in the world because they're never going to get more than a dozen signatures. To get the serious ones, and then to start at that point questioning the language, holding hearings, calling the proponents in, and doing a very, very thorough examination of what is intended by the proposition. I say do it at title and summary because you've got the period of time that would otherwise be where they're going to be circulating it, and you have longer than the time of it's qualified, it's going to be on the ballot. Excuse me. So those two things for starters. We'll get somebody who hasn't asked a question. Ma'am.
Is there a way to affect the wording of propositions so that you're not no, or vice versa? You know what I'm saying? A lot of times people are so confused they don't know what.
No, I know. But it's not a good system. It's not a good system. Yeah, you can't affect the wording. Once it's circulated, the wording's in concrete. Because when they circulate a petition, it's got title and summary. It also has a full text in the measure. So when you sign a petition, that's all there when you sign it. Yes, ma'am.
Regarding your last comments about the procedure you would like to see, isn't that the indirect initiative procedure?
Well, indirect. No. The short answer is no. I'm suggesting something that is akin to an indirect initiative, but is really a. With the indirect initiative, the legislature can actually fool around with the initiative itself, and then in California they had different, requirements relative to the number of votes to get it to the ballot to try to persuade the proponents to work with the legislature. I'm just saying competing initiative, competition to initiatives. And many states do it, and whether or not that's technically considered indirect or not, I mean, that term has many meanings. But it just, think of it as a competing measure that's proposed by the legislature that accomplishes, that's a counterpoint to the measure that's been put on by whoever. And you give the voters a choice. Right there.
I'm so confused about Prop 13. Are we stuck with that?
We're stuck with it until they change it by an initiative measure. See, I mean, that's another really goofy thing about the initiative, and let me talk inside baseball for a while. The California Constitution sets forth vote requirements on how the legislature can pass a statute to be considered by the governor. The general rule is it's a majority vote. Certain things require a 2/3 vote, like an urgency measure, something that goes into immediate effect, like an appropriation from the general fund because of Prop 13. But those are set forth in the Constitution. Unless it says it's a 2/3 vote, it's a majority vote. The initiative process has spawned this language that in a statutory initiative, which normally cannot be amended by the legislature except by another measure placed on the ballot to amend it, unless the initiative allows for its own amendment. Well, what they've done in initiatives is they put super majority requirements. 2/3 vote to change for the legislature to change this initiative, and only to further its purposes. Well, further its purposes is, the eye of the beholder. The 2/3 vote isn't. So we've created by initiative super statutes that outside of the Constitution, where by a statutory initiative, the people impose a higher vote on the legislature. I don't think that they can do that. But what it does is it provides a lot of uncertainty in law, because we pass an initiative today, and then the next legislature says, well, we think it can be fixed. We're going to fix it and say it furthers its purposes, and we're going to do it by a 2/3 vote. Okay? Regular initiative, original initiative, the legislative fix. The next year, they thought, that's not such a good idea. What's the vote requirement to undo it? Is it 2/3? Is it a majority? And as something like the Political Reform Act, which takes on a life of its own, where there have been literally hundreds of amendments, somebody should be keeping track of what was part of the original initiative and what was an amendment done by the legislature, because they're two different acts. And if you look at the Constitution, you would conclude it's just a majority vote. So doing this, allowing statutory initiatives to kind of gum up general law is also a bad idea.
One of the proposals relates to this, and proposals for reform relates to this very issue. And the proposal is that if it would require a 2/3 vote to do something, then it has to pass by the voters by a 2/3 vote. What do you think of that kind of approach?
I'm really against supermajorities. I really am against supermajorities. So let me give me another example. Okay, we think it's a good idea that a certain class of of constitutional amendments, which require a 2/3 vote of the legislature to appear on the ballot, have to be adopted by a 2/3 vote of the by the people. So we have to make that constitutional amendment and it's got to appear on the ballot, and a majority of voters approve it. So now the new requirement is a 2/3 vote. How do we get rid of it? What's the vote requirement? He says the voters change their mind. What is the vote requirement to eliminate the 2/3 vote requirement? And who imposed it? A majority of the people. So, I mean, I think there are fundamental problems with supermajorities. You either have a democratic society where it's a majority rules, obviously with constitutional restrictions, or you don't. And so, yeah, I'm lukewarm on that one.
On this initiative and referendum process for the league, the second one says that California should adopt an indirect initiative procedure, preferably as an optional alternative to the direct initiative. And I don't know the difference.
Well, I mean, as I said, indirect is a loose term. As they're using it in that document, I think they're talking about what I'm talking about. A direct initiative is the people put it on the ballot, that's it. And I'm fine with that not changing. But I think contemporaneously, the legislature should be able to put a competing measure on the ballot. Well, indirect generally means that collaborative process between the legislature and the proponents in a hybrid. Which it wouldn't be, I mean, I do it the Swiss way. You have the original proposal, you have a compromise that was worked out with the proponents as a fallback, but they really don't want to dump their original idea, and we have the third way, the pure way that the parliament wants to do it. You put all three on the ballot, you have information on all three, and you let the voters decide which is the proper approach. I mean, I think that's the best way of doing it. Another question?
I have a question about Prop 13. If you give your legal opinion, I don't know if it's open to interpretation. If you wanted to eliminate the commercial property portion of property,
Split roll.
would you be able to do that only by an initiative?
Only by an initiative.
By a majority vote?
By a majority vote.
So it wouldn't be impossible to do that.
No, and it's tossed.
That's some of the worst.
No, that idea is thrown around all the time. I mean, the thing that snuck in on Prop 13, the deceptive thing about Prop 13 is the whole campaign was about residential property when the people behind it were commercial property owners, and they're the real winners. That was the deceptive part of it. The hidden part of it was the 2/3 to appropriate.
What about the idea of having a process before an initiative appears on the ballot that would have to go through like a legislative analyst?
That's what I said. I would say a vetting process.
Okay, a vetting process. And it would be checked for legality,
Right.
ramifications, transparency, all of that before it went on the ballot.
Well, see,
Or even before signatures were gathered on it. It would be like,
were we talking about something that can be adopted, or are we talking about something that in our wildest dreams we think would be the most wonderful system? I mean, I agree with you. I don't think anything should appear on the ballot unless it's totally vetted. I don't think it should be circulated. I think that the people who sign the petition should know what they're saying. I don't think there should be paid circulators. You know, I think that people who circulate petitions should be registered in the county that they circulate. All these ideas. Court has said no, 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 and the people seem to be, generally happy with the system as it is today. And any change to that system is going to be fought tooth and nail by those who benefit from the current system. So when I talk about changing it, I talk about changing it kind of incrementally, focusing on certain problems, trying to convince the court to take a different approach, and to be able to say to the voters, you're not losing by adopting this reform, you're gaining. You're getting more choices, you're not having fewer choices. Doing what you suggest, which I agree in a perfect world would be the way that I'd do it, has no chance of passing. Because they're saying, and I can see the campaign against it. Those crooked politicians are trying to prevent the people from doing things by throwing roadblocks in the way and yada, yada, yada. And so, I don't disagree that there are many, many better ways, and if we were starting with a clean slate, we could come up with a system that's a lot better. I think given the existing political realities, we have to take more incremental approaches at it. Yeah.
What
I'm so discouraged. I'm sorry. You say I'm young, but I'm old. I'm so discouraged. Joe Matthews and Mark Paul wrote a book called California Crack Up. Have any of you read this book? If you haven't read California Crack Up, go out and buy it. It is the best book on, it says how reform broke the Golden State and how it can be fixed. It's a great history of the initiative and how it came about, and it has some very, very interesting solutions on how to fix it. I'm upset about this book for two reasons. Reason number one, I didn't write it. And I talked to the author on the way over because I'm going to try to get him to come and talk to my class, and I made that point to him, which I make it every time. But the other reason that it's so upsetting is it's there. It's out there. It's been out there for a while. And is it having an impact? Not that I see. I mean, you have this perfect exposition of what the problem is, chapter and verse, citations, a history of how it occurred, and what the sensible things, ways it can be fixed, and not even a ripple yet. So I'm discouraged. I'm discouraged. You got California Forward. You've got I can't think of off the top of my head the name of the other group. These are bankrolled by powerful interests in California that are more neutral. They're not. And it's not like Mercury Insurance that wants to increase the business, but it's like big industrialists in California that I'm told meet from time to time and have real qualms about the direction the state's going and how decisions are made. So they're funding some very, very capable people who are doing a lot of work. They're not getting any traction.
Are you talking about California Forward?
I'm talking about California Forward. They're not getting traction. They had something on the ballot last time that didn't even get any attention. So I'm sorry to do this, and maybe I should stop going around talking. But I am a pessimist on something good happening. Ma'am.
And this may be a dumb question, but I questioned Proposition 30, and I can't really remember too far back to all these things in 98 and stuff like that. But Proposition 30, was this not a two-subject ballot?
Which Proposition 30 are we talking about?
Yeah, I mean Brown's job.
The Brown one?
Yeah.
On the basis of what would you say it's two subjects?
Well, one of them was about sales tax, and one of them was about income tax.
And what do those two things have in common? They're both taxes. See, that's what I'm saying. The California Supreme Court, I love the Political Reform Act. I think it was a great enactment. The Political Reform Act was over 100 pages long. Its subject was political reform. It covered conflicts of interest, registering lobbyists. I can go through the whole index of it. It was the whole notion of political reform is so excessively general that it swallows the single subject rule. The subject of taxation is so excessively general, it swallows the single subject rule. But the way the courts look at it is, if you can get, and I quoted, and you know what I'm going to quote from? I'm going to quote from League of Women Voters versus you. Thus, a measure will be considered in compliance with the single subject requirement, which prohibits submitting to the embracing more than one subject if provisions are either functionally related to one another or are reasonably germane to one another, or the objects of the enactment. The standard does not require that every provision of a measure interlock in some form of functional relationship. That's what they said in League of Women Voters versus you when you folks tried to take a ballot measure that was tied in with welfare, when you tried to prevent it from being on the ballot. And they said, doesn't have to be it's functionally related, reasonably germane. They don't have to interlock. So, what's a single subject? So that's why I say when you start out, you say, number one offender, California Supreme Court. Let's get out of fantasy land. Let's recognize initiatives for what they are. Let's not liberally construe them. Let's strictly construe them. Let's come up with a meaningful single subject rule that really means a single subject. Let's come up with a meaningful differentiation between an amendment and a revision. And now we've set new rules. No law has changed. decisional law has changed. The view of the court has changed in view of reality to like make these very fundamental changes to rein in the initiative process. Because we're the Wild West out here. No other state has initiatives like this. Oh, no, this gentleman has an answer.
You laid out a two-step process for the most likely to succeed approach. And the first step was legislative action to put an item on the ballot
right.
that would
compete, for lack of a better word.
Allow the competing initiatives or law to be offered to the public to vote on. But it seemed to me that, from what I heard you say earlier, that might not even be necessary. That might be more pro forma, and it seems to me like that would be the first place that a problem will surface, because to convince the general public that you should be tightening up the rules on the initiative process, because there is big money influence that's driving the initiative process, and we should go and rely on the legislature, who we have to convince the public that they're free of the big money interest.
Well,
I don't think that would be so easy to do when you look at the privately sponsored bills, the success rate.
Yeah, no, I know. I mean, let's beat up on the legislature. You elected them. I didn't. I elected my own member. Yeah, I mean, I guess the question is, do you want decisions made by the legislature that is influenced by special interests, or do you just want the special interests do it just the way they want to do it, just without any constraint? It's a good point. No, it's a good point. Look, this is an imperfect system, but I mean, I'd much rather have. Look, I'm going to say it. I'm being recorded. I trust the legislature more than I trust special interests. Although I understand the special interests oftentimes listen to the legislature, depending on who the party in power is. It depends on which special interests they're going to listen to. Right. I understand that. That's sort of a problem with our democratic form of government. I mean, maybe we want to elect people to the legislature in a different way. Maybe we want to screw around with campaign financing. But now that corporations are persons, I'm not sure that that's going to make much of a difference. But I mean, did I earlier say I'm really pessimistic about solving this problem? Yeah, I'm really pessimistic, as happy as I may seem. Ma'am.
When you were talking about being a bit pessimistic, and then those books that were out that were so
right.
good, and the lack of response to them, how do you see that being affected by the fact that so many people are getting their information in little chunks of information and don't seem to read as many newspapers, look at long articles, want things in 40-character tweets? I mean, do you see that kind of effect?
No, I never, and I never thought I would get to this place when I was younger, and decrying the youth of today, the way, hearkening back to the way it was done in the old days. But no, look, your point. Your point is, I'm addressing your point. Your point is that people don't read; they get information in a different way. That how it's packaged is more important, and oftentimes, than what the message is. I'm looking at the California Supreme Court and the legislature after it's been term limited for 20 years, and I don't even think they understand the procedure. They don't understand the process, much less how to do it correctly. So there is a real lack of information and a lack of the transfer of knowledge that has gone on over the second half of the 20th century leading into the 21st century that I don't know how you address. And so I mean, it's a problem. As I said, I try to be as cheery as I can, but I'm pessimistic about this back there.
Can something be done about deceptive advertising?
No. Free speech. Can something be done about deceptive advertising? Deception is in the eye of the beholder. No. True facts. Ask Arnold. Good.
We only have a few more minutes for questions, but I think the Secretary of State forced all propositions onto the general November ballot, no more primaries.
Well, the California Constitution requires that, and ironically, it was a political reform act where The thought was it was breached because it was put on a primary election, but that primary election, for a reason that eludes me at the moment, was, I think, also a special election. So it did qualify, but then subsequent Secretary of States, not realizing the differentiation in the Constitution and never being called on it, started putting them on primary and general, primary and general. My understanding is that this rule in the Constitution has come to their attention and that the Secretary of State is now enforcing it.
Which has made it more of a problem, I think.
Well, it's more of a problem relative to, yeah.
The dumber the voter, the better a lot of people like it, and the more items on the ballot, the
Right.
less ready the voter is to deal with all of them.
Right. That's why I think that the best way is the Swiss way, where you just have an election for the measures. Maybe we've had enough. Thanks very much for your attention.